Can you accept the request?
Perfect. Thank you so much. And I'm going to pass it on to my colleague Shankari.
Hello, welcome everyone. My name is Shankari Balendra. I'm the self-represented litigants worker and case manager at the Schleifer Clinic. Very happy to welcome you all, and just a brief information about the self-represented project. So this is a special project done by our clinic. We assist clients who are self-representing and in areas of law which there is not much support available. And for any information about that, you can contact me or you can check our website as well. Coming to the webinar, uh, the overview of today's webinar is first, we are going to talk about application on humanitarian and compassionate grounds. So, what is an application? What are the eligibility criteria? What are the basis for humanitarian and compassionate applications? And also a little bit details about the two-stage process of approval for the HNC application. Just because the name is too long, many times our presenter will be using HNC, which of course refers to humanitarian and compassionate grounds application. And also we are going to talk about preparing the HNC application, what sort of evidence to include, and how to access and submit the application. The main purpose when it comes to self-represented litigants, of course, our presenter will later on discuss, they will need legal advice, but at least for them to be informed, to prepare before they make an application. So when they see a lawyer, they are ready with information, they are ready with evidence, and they are more informed. That's the purpose of this presentation. Thank you. Over to Yasmin.
Okay. Good morning, everyone. My name is Yasmina Buzgaya. I am a lawyer at the Barbara Schleifer Commemorative Clinic, and today we're going to be doing a brief overview, this is how I would describe it, of this particular immigration application. It is, in essence, called an application for permanent residence based upon humanitarian and compassionate grounds. As my colleague Shankari mentioned, we will be using the shortened version of the reference to this, which we call H and C. And we'll start by discussing what it is. So what is a humanitarian and compassionate application? It is essentially an application, a request made by an individual who doesn't necessarily meet the regular requirements for permanent residency, but who has compelling reasons and wishes to remain in Canada due to exceptional circumstances. It's important to note that these applications are assessed on a case-by-case basis by IRCC. Next slide, please. As I said, they are really meant for people who are currently in Canada and have compelling reasons to remain in the country, despite not meeting the standard criteria for permanent residency, right? So because agency applications, it's important to know that agency applications are highly discretionary because of this. They can include children as dependents, but there are some limitations around it, such as long processing times, pretty significant fees, and there's no real automatic qualification for assistance. Before we really get into it, it's also important to know that even if an agency application is in process with IRCC, it does not automatically stay or stop a removal from Canada. Okay, so if CBSA, the Canada Border Services Agency, is actively trying to remove an applicant or a foreign national from Canada, having this agency in the system with IRCC won't stop or delay a removal, but it can be part of an argument as to why a stay or a pause from that removal should be granted. Okay, next slide, please. Agency applications provide a pathway to permanent residency in Canada under unique circumstances. Like we said, evaluated on an individual basis, and they consider various personal and compelling factors. However, There are specific conditions where you're not really eligible to apply. For example, if you have an active refugee claim, you would have to withdraw it before submitting an agency application. There is also something called the 1-year bar, meaning if you had a refugee claim in process that was heard, rejected, or if it was abandoned, or if it was withdrawn within the last 12 months, you would generally not be able to make the agency application unless, for example, there were the best interests of a child that would need to be assessed. So there's a child that's involved in the application in some way. It's also important to know that although multiple agency applications can be submitted, repeated applications without new or significantly changed circumstances are not likely to succeed. Next slide, please. So continuing on the topic of eligibility, like we said, while humanitarian and compassionate applications offer a pathway to permanent residence in Canada under special circumstances, there are specific bars or limitations to eligibility. These can affect the outcome of the application or make the individual ineligible to apply. So here are the main bars to eligibility for an agency application. You cannot make an agency application if you've applied for a pre-removal risk assessment and you've not yet received a decision about your assessment. You can't make an agency application if you're already deemed inadmissible for specific reasons, such as you're a danger to Canada's security, you're suspected of being involved in terrorism, organized crime, or espionage, you've been suspected of committing human rights violations, or you've been designated a foreign national. You've become a designated foreign national within the last 5 years. Next slide, please. Okay. So here we're going to go more into what the basis of an agency application is. Okay. The agency is, in essence, a paper application, and you, as the applicant, would rarely be interviewed. The decision, like we have said, is highly discretionary, and you'll hear me say this multiple times. What that means is there is not necessarily a very specific formula or bar, and each officers can make different determinations on a case-by-case basis. For this reason, it can be very difficult to advise an applicant on the chances of success of their agency application. The agency is what we would call in the immigration world of the catch-all application. It can be used for applicants who may not quite fit into other immigration streams, but nevertheless have compelling and convincing reasons to remain in Canada and be granted permanent residency. In terms of the actual agency application, there are 3 main elements that an officer would focus on when making a decision. And we're going to be going into those different elements in this presentation. So what is the extent of the applicant's establishment? 2, what the applicant and any dependents included face any hardship if removed from Canada? And 3, will the return of the applicant to the country of origin affect the best interest of any child? I see that there is a concern around the sound. Can you hear me?
Yasmin, we can hear you, but your volume is coming really suppressed. It feels like, yeah, if there is a way. No, don't apologize. I think I could hear you, but I was wondering if there is a way to maybe
the best possible thing is probably for me to speak louder.
Yes, to project your voice, exactly.
So I will project. My apologies, everyone. And if at any point I start mumbling again, as I have a habit of doing, please just flag it for me in the chat and I will see it and I will be louder again. Okay, thank you very much. So just to be clear, in terms of the actual agency application, there are 3 main elements that an officer would focus on when making a decision. 1, what is the extent of the applicant's establishment? 2, will the applicant and any dependents included face any hardship if removed from Canada? 3, will the return of the applicant to the country of origin affect the best interest of any child? Okay, now we will, at this point, we're going to go over briefly each of these elements separately and the factors that you would need to consider when preparing the application to address each of these. Next slide, please. Okay, so the first element that we're going to be considering when completing an agency application is the element of establishment. It's extremely important for you, the applicant, to show that you and your dependents have established strong connections in Canada. The IRCC processing manual provides some guidance in this regard. It basically states that a positive decision may be made when the period of inability to leave Canada due to circumstances beyond the applicant's control is of considerable duration and where there is evidence of significant degree of establishment in Canada. What does that mean? How does that translate? What that means is it's important to include as much evidence as possible to IRCC on the degree of the establishment within Canada. What are the ties to Canada, right? And this evidence should be provided to IRCC on an ongoing basis while the application is being processed. So what are some of the factors that we can, or some of the evidence that can be included to show this element of establishment? Okay, one is the duration of the stay in Canada. How long have you been in Canada, right? 2, do you have friends or family members in Canada? Any education or training that has taken place in Canada? Any jobs or volunteer work? And what was the employment history in Canada? And is there any evidence of participation in community events or memberships or organizations within Canada? All of this evidence could go to show and prove establishment and would go to this establishment factor within the application. Next slide, please. Okay, so the next factor we're going to be discussing is the element of hardship. Okay, the assessment of hardship in an agency application is a way by which the IRCC officers determine whether there is sufficient agency grounds allowing an applicant to make a PR application from within Canada. So when considering the hardship factors, individual agency factors are not considered in isolation. Rather, there is an assessment of all of the factors as a whole that have been raised by the applicant. So this would include, for example, any hardship that the applicant or their dependents would face if the agency application is not allowed and if they are forced to return to their country of origin. The issue with the hardship analysis is that there is no concrete definition or test for hardship in the IRCC policies or processing manuals. Case law has been relied upon, essentially, to determine or decide what an applicant must demonstrate to satisfy the hardship elements. But because decisions of immigration officials are not often published, and decisions of the federal court, for example, are pretty much the sole source of information on this point, there has been some inconsistent case law that has resulted. So it's difficult for applicants to understand what factors or how to best put forward information around how to establish the hardship criteria. Okay. Now, the IRCC processing manual does provide some guidance with respect to these factors. And these factors could include, any violence or abuse that the applicant might face if they were to return to the country of origin, any human rights concerns or discrimination or harassment in the country of origin, a lack of access to adequate medical care, including mental health concerns that the applicant might have. If there's a lack of family and community support in the country of origin, if there is, for example, a possibility of returning to conditions of poverty, such as the general economic conditions or inability to find work in the country of origin, and it's important to also include the consequences of separation from their relatives in Canada, including any Canadian-born children. It's important to note that those risk factors that are relied upon in refugee claims, such as persecution, risk to life, and cruel and unusual treatment, are not directly considered in agency applications. However, the basis of those risks can be useful and adapted as part of the hardship analysis in the agency application. And it's also important to know that the test for hardship in an agency application is broader than in a refugee claim. Next slide, please. The next factor that is considered is the best interest of any child that would be impacted by the decision. So what does that mean? That means an immigration officer must take into account the best interest of any child that is directly affected by an applicant's removal from Canada. Now, that child could be the applicant's own biological child, including a Canadian or a foreign-born child, can be a grandchild, or another child that the applicant shares a close relationship with. Okay? Some of the factors that should be considered in this best interest of the child analysis are the age of the child, the level of dependency between the child and the agency applicant, the emotional impact of being separated from the applicant, who may or may not be their primary caregiver, the degree of the child's establishment in Canada, the child's links to their country of origin, and the conditions of that country and potential impact on that child, any medical issues or special needs that the child might have, and what the impact would be to the child's education if they had to leave Canada. Also, any issues related to the child's gender. Next slide, please. Okay. So now that we've gone over really the three main factors that are considered in an agency application, it's also important to know that there are two stages of approval for these applications, okay? For an agency to be successful, you would have to pass both of these stages. In stage one, you are applying for the permanent residence in Canada based on humanitarian and compassionate grounds. And that includes several things that you would have to submit, including one, the forms. So you would have to fill out the IRCC forms that are related to this agency application in their entirety, make sure they're signed and submitted, along with this larger package. This larger package, like we said, includes the forms, it includes the fees for the agency application, it includes personal documentation that you're going to be providing that goes to these three factors that we discussed: the hardship, the establishment, the best interest of the child. It also includes, well, it should include either a statutory declaration or an affidavit. And that essentially is a sworn document that would include information about the applicant that hits all of those three factors that we discussed. So a persuasive statutory declaration or affidavit would include a history of how the applicant came to Canada, how established they have become here, what their ties are here. It would go through all of those factors like we discussed: their employment, their education here, family ties. It would discuss the hardships in the country of origin. It would discuss the best interest of any children and ties to any Canadian-born children that are here. And it would essentially make that persuasive argument about the client or the applicant's experience within Canada and why they have exceptional circumstances and they should be permitted to apply for permanent residence from within Canada. Other documents that can be included in this first initial package include country conditions documents, which we're going to talk about in a little bit in this presentation. And those technically go to the hardship element, as well as any legal submissions if you have a lawyer who would assist you to put together some legal submissions and include in this first stage package. Now, I know that sounds like a great deal because agency applications are generally quite voluminous and do require a lot of information to go to IRCC. But if all of that is submitted to IRCC and it is approved at the first stage after it is reviewed by an IRCC officer, then the applicant moves to the second stage of the process, where they have to fulfill a few more requirements that are generally a little shorter and more straightforward than the initial first stage package application process. So in the second stage is sort of where they assess if you're admissible to Canada. So the applicant would undergo a medical test. They would provide a criminal background check from the country of origin, any other countries that they've lived in. They would provide a copy of a valid passport. They would provide, proof that they are financially self-sufficient, and they would also pay the second fee that is due, which is the right of permanent residence fee. It is important to note that applicants can get waivers from these secondary requirements if necessary, and if they have a compelling reason. Next slide, please. Okay. So when you're preparing the agency application and all of that information has gone into IRCC, the immigration officers would consider all the evidence within the application and are required to consider all of this evidence as a whole when deciding whether or not the application is strong enough to approve. That means that it's important for you as the applicant to explain all of the reasons why you should be granted permanent residence from within Canada. And that's why it's important to send the best possible evidence to support your application and to collect as much evidence as possible that could support your application. And it's also important to know that even if after you've sent the application package, at least for the first stage, you can continue to update evidence as you receive more and as you collect more evidence in support of your application. Next slide, please. Okay. Here are some examples of evidence that can be included as part of the personal documentation portion of these agency applications. Okay. For example, you can include letters of support that would strengthen your agency application. It would provide firsthand testimony and validation of your circumstances. These letters often are written by individuals who are familiar with the applicant and the situation. They could be friends, family members, employers, community leaders, service providers, teachers, people who have a relationship with the applicant and can give insight into the applicant's character, contribution, and the challenges they faced. So, as much evidence and personal documentation as you can put together and as many letters of support as you can collect, that is what the aim is, and that is what would be, as persuasive as possible for the IRCC officers. Next slide, please. Other evidence that you can include as part of your agency application include reports and records. So for example, if you have medical or hospital records, reports of any injuries or trauma that relate to family violence, a diagnosis and treatment plan, for example, for any medical condition that you can't get adequate care for in the country of origin. If there's any police or incidents reports that can show that police, for example, were involved because of family violence. If there is court records that can show things like criminal charges against the abuser, or if there's court documents like family court applications and hearings that are ongoing within Canada, that can be very helpful as well. Financial records are also useful as part of this evidentiary record that you're putting together for IRCC. Financial records include, for example, T4 statements, notice of assessments, CRA statements, or bank statements, just showing that you're working and that you have an income coming in. You could also provide them with psychological assessments that could show, for example, if a child has special learning needs, or it could show how being forced to leave Canada could affect this child, such as the impact of returning to the country of origin where they suffered trauma, or if there's a psychological assessment that could be done for the applicant themselves to show the impact of having to return to the country of origin and how that could affect their mental health. Next slide, please. Okay. Staying on the topic of the types of evidence that can be included in these H&C applications, as part of the evidence of hardship, you can put together what we call country conditions documents. And those are really like reports or evidence from experts or from articles or from peer-reviewed journals that speak directly to the hardship in the country of origin. And this can really support an H&C application because it provides evidence that demonstrates how the culture or customs could impact the safety and well-being of the applicant. It can show how the applicant could be discriminated against or treated badly because of their race, ethnicity, gender, or sexual orientation. It could speak to the point that they would not have adequate medical care for a condition that they have been diagnosed with. Or it can show that there are no supports for people who have a specific disability. It can also show that victims of abuse and violence and gender-based violence are not protected in the country of origin. So they are a useful and very persuasive element of the overall H&C package. Next slide, please. Yes, so essentially, if you are claiming hardship or the applicant's claiming hardship arising from circumstances in the country of origin, you do want to include supporting documents that show the hardship that you would anticipate, whether it would be faced in all areas of the country of origin, and whether you've also sought assistance from the authorities, including police or non-governmental organization in that country of origin. Okay, next slide, please. Okay, so how do you access and submit this H&C application? Currently, H&C applications are now being submitted online through the IRCC portal. If you cannot apply online and you require accommodations, you can contact IRCC to ask to submit the application in another format. The application is available only in French or English, but you can get a Braille or paper copy, and that can be requested by contacting IRCC. It is important to know that the processing times for these H&C applications are currently very long. The last I checked, which was recently, they are processing between 20 and 36 months for the first stage approval at this time. But we have seen cases where it is processed more quickly than this. The fees for the application can also be a bit of a barrier for applicants. The current fee requires adults to pay about $635 for the first stage as a processing fee. Children that are included as dependents, meaning they're not Canadian-born children, would pay $175 each to be included. And then if the applicant is approved at the first stage and it moves on to the second stage, there is a right of permanent residence fee that is due for the adults at the second stage, and that amount is $575 currently for each adult. So it is extremely important when you are submitting the H&C application to refer to the document checklist and understand the specific documents and the specific forms that are required to submit this application. Okay. It is also important to ensure that any documents that you are providing IRCC that are not in English or in French are accompanied by an English or French translation and an affidavit from the person who completed the translation if they're not a certified translator. Okay, next slide. Okay, Here is a list of some of the forms that have to be filled out when completing and submitting the agency applications. They are all on the online portal, so you'll be able to see them there and you'll be able to submit them all there. However, it is important to check the agency. There is a agency sort of guide as part of the document checklist. There's a guide that's online that will walk you through each of the forms and what needs to be included as well. Next slide, please. That really sums up the brief summary of these agency applications that that you can put together. But it is one of those immigration applications that if you are able to work with a lawyer to put together, or at least have them assist you maybe by reviewing the documents, or provide you with some legal submissions in addition to the documents that you're providing them, we would strongly recommend that. It is just one of the more voluminous and time-consuming IRCC applications. And so I imagine there may be many questions in relation to this. It was a very quick and sort of information-heavy presentation. So we're happy to field any questions that you might have at this time.
And you can either write in the chat or you can unmute yourself if you'd like to ask a question.
Yeah, I think that people are trying to think about questions. Can I ask you something to get us started? So, a common struggle that people have is around understanding the timeline, because we all know that it is unpredictable. But I was wondering, from your own personal experience, what are the kind of timelines? What is the variety of timelines for us from starting of an application to the finish? And if you could also add to the complication of just gathering of the evidence piece, because people should account for how much time and effort that can take.
Yes, so that's a great question, or a great fact that we should speak to, which is these agency applications, in our experience, are some of the lengthiest and most time-consuming applications that could be made to IRCC. As you saw in the presentation, I sort of broke down the timeline into the different stages. So stage one, generally speaking, will have the longer timeline for processing. And that means that first package that you're putting in with your forms, your fees, and your evidence, that will take quite a long time. It looks like it's up to 36 months currently, just to process, for them to say to you, okay, you've got this first stage approval, you can move on now to the second stage. The second stage is generally shorter. We've seen some processing times, depending on how quickly people can get, for example, their criminal background check, how quickly they can provide, a valid passport, how quickly they can put together those last right of permanent residence fees. That can be done within a month or two, if in a really quick case, right? So the second stage is, generally speaking, a little bit faster, or can be significantly faster than that first stage timeline. Having said all of that, the bulk of the time that an applicant is going to be spending is going to be on that evidence gathering, because it can take a very long time with other, life circumstances and, responsibilities. It can take a very long time to collect, the letters of support from the people in your life or from the organizations that you're involved with. It can take a long time to put together all of that financial evidence that goes to support your application. to put together a persuasive affidavit or statutory declaration, right? With your story and your narrative in it. All of that will take and putting together, pictures of the family or information about the child or your medical information or police records, whatever it is, can take a long time to get all of that information and evidence together to go in that first package, to go along with that. And that's why it can be important to start with what you have, right? And continue to update as you gather more evidence. You want to start with a good amount, a sufficient amount of evidence that you can put forward. And then you can always build on it as you're collecting more evidence to send to IRCC. So you can always update your application. Once you have the application in the system, you'll get a little you'll get a notice from IRCC, a letter acknowledging the receipt of your application. It'll have your UCI number, your unique client identifier, and you will be able to use that information. You can send even email updates to IRCC by emailing their Vancouver office with those updates that you have. So the sooner you start collecting your documents and your evidence, the better it's going to be for you, the faster the process will go. And know that you can always continue to gather and continue to update them as the process goes along. I saw that there was a hand that was raised.
Yes, it's Sabia, and thank you, Yasmin.
Hi, Yasmin. My question is, if the agency application is refused, what options does the applicant have after that?
Great question. So you can appeal a refusal of an agency application to federal court, judicially review that application. That is it can be costly and will generally require a lawyer to assist you with that. But there are cases, for example, if the first application has been denied and the client doesn't want to judicially review it, or they don't have strong grounds to judicially review or appeal that decision to the federal court. But sometimes between the time of the initial application and the refusal, the applicant's situation in Canada has changed, right? Their establishment has become greater. They maybe have had a child within Canada. They have stronger ties, more family members, or a longer work history. Their circumstances may have changed so that it makes it advisable to potentially submit a second agency. If their circumstances have changed enough or have shown that there has been, quite a significant change in establishment, it can be useful actually to consider submitting a second agency based on these new circumstances, especially if they didn't provide enough updates in the first agency application. Okay. Does that make sense?
Yes, so that's again like the whole process just renews, so that's another like 36 to 40 months in the whole application.
Sure.
Okay, got it. Thank you.
Of course. Any other questions?
I have a question.
Yes.
So I was just going through the basis of applications, different criteria. One is that medical conditions, like sometimes there is this misconception, like clients think that if they have a medical condition, it's like putting more strain on the healthcare system and that the application will be rejected under that basis. Do you want to tell about that, please?
That's a great point you brought up. Sorry, thank you. Essentially, that depends on the circumstances. There is a situation where, for example, in the second stage of the application, stage 2, if you progress past stage 1 and into stage 2, part of the admissibility criteria that IRCC looks at is the medical inadmissibility criteria. Having said that, it's a quite high bar. What I mean by that is it's not as if if you have some medical condition or any medical condition, you would be considered inadmissible to Canada. You would have to be a very, very significant burden on the system, on the healthcare system within Canada, to be considered medically inadmissible. So, for example, if someone is a diabetic, or perhaps they have PTSD or another mental health diagnosis, that has the ability to be treated in Canada without much or any sort of burden, quote unquote burden, excuse me, on the Canadian taxpayer, on the Canadian healthcare system, then those should not be a bar to this medical inadmissibility or the medical admissibility criteria. So I would say it would be useful for the applicant to show if there is, for example, treatments in Canada that they cannot easily access in the country of origin. It's still advisable to put that information forward if they have mental health concerns, or if their mental health would deteriorate if they were to leave the country and be forced to return to the country of origin, right? That can be put in with a special focus on any medical needs of the children, right? So if there are children who have specific medical needs that could not be adequately addressed in the country of origin, or it would disrupt, for example, their current medical treatment and cause some sort of degradation or damage, then that's important, very, very, very important to highlight in the application, because that directly goes, to the best interest of the children. Does that answer the question, Shankari?
Yes, thank you, Yasmin.
I know that was a very large chunk of information in a very short period of time. So
Yasmin, I see Cheryl has unmuted, so I wondered if Cheryl wanted to ask a question.
Deepa, your eyes are very sharp. Okay, so yes, so I know that quite a few clients would not have status, right? So clients who are applying for do not have status. Okay, now, however, I've always heard that, okay, if you're applying for H&C, it's not a good thing to go on OW. However, a lot of the clients cannot work because they do not have. So what are the complications, and is that true, and how do you work around that? If you get the question. Yeah.
Thank you so much, Cheryl, for that question. So it's important to note that with the H&C application, a client doesn't necessarily have access to the same social benefits that they would have under different immigration applications. So if they were a non-status applicant, for example, and they have not yet applied for an H&C, they would not qualify generally for Ontario Works and would not be able to apply for Ontario Works up until they have at least submitted that H&C application. Is it as part of the second stage requirements? They do look at financial self-sufficiency as part of the considerations that go. It's one of the bars to getting permanent residency at the second stage. But waivers can be obtained, meaning if there is, for example, the client might be on Ontario Works temporarily because they are a new mother, or they have some very young children and they're unable to currently work, but they have specific plans, and they have discernible plans for returning to work once they have the permanent residence. That can all be included as part of submissions in the second or in the first stage of the application. Having said that, it's not uncommon for non-status applicants to work under the table and without work permits. And I have, in at least speaking practically from our experience at the clinic, I've yet to see a H&C application be denied based upon the fact that an applicant is working essentially under the table or is working without work authorization. It does go directly against the regulations. You're not supposed to work legally without a work permit, but at the same time, officers understand that humans have to survive if they're here non-status, right? And there is that second stage requirement showing that, they want the applicant to be self-sufficient. So it's sort of a balance of, is this a client who should be going on social assistance because they have, a very compelling reason to be on social assistance, and we could potentially get them a waiver from that financial self-sufficiency requirement at the second stage? Or is this something where them continuing to work would not directly impact their application? Does that make sense, Cheryl?
Yes. Thank you.
Yeah, Yasmin, if I may add, I just want to say that it's a very case-by-case assessment when it comes to that particular nugget, because people sometimes when they're navigating being non-status in the country, especially for survivors who have experienced multiple traumas, sometimes applying for housing, applying for income security, getting medical coverage, access to education, all of those could be based on are these their priority goals versus getting the status and the merit of the status application or the nature application. So I would always encourage everyone to talk to a lawyer. There is nothing wrong in having those goals be accomplished versus maybe not having a very meritorious agency application if that's what your client wants. But it's all about your client's goals and what they really need to be sustaining in this country. I put 2 resources as links, which are from on Clinic's website. One is a toolkit that came out of some work that I did as part of my fellowship, which gives you a chart of various different application processes and what can you qualify to apply for. And the second one is on the evidence gathering of agency application. And these were the ones I was mentioning in the beginning, that we have some resources on our website, which are these ones, but there are many more. I would encourage everyone to check those out. But thank you so much, Yasmin. I think you weighed on the question legally very accurately. I just wanted to say that, our clients are so different in different situations.
Oh yeah, absolutely. It's always, with these specific applications, it is a very case-by-case determination depending on the needs of the client, their particular factual circumstances. No two agencies really will look alike, in my experience.
I'm looking at Kalandra and Shankari for their permission that if we have no more questions, do we want to wrap up? I would like to start by saying thank you to Yasmin for this brilliant presentation. Thank you so much. And over to Kalandra and Shankari.
Yes, I want to reiterate our thanks to Yasmin as well. Thank you for graciously doing this presentation with us. As well as I want to thank Deepa for making time to being here today, and Shankari as well for her work on this presentation. With that, Shankari, if you don't have anything to add, I think we can come to a close.
Yes, sure. Thank you very much, Yasmin, Deepa, and for all the participants. Yes, I think we can finish the presentation now. Thank you very much.
Thanks, everyone.
Thank you, everyone. Please keep looking at our website and our social media. We have more presentations coming in future. But thank you so much for attending today.